lakh certificates have been cancelled. One more thing, Manoj. Unmindful of the High Court order, there have been subsequent recruitment processes where they are going back with the same lists have been watched. They are coming here and saying they are having difficulty. We have not filed any content. Your lordship have posted in January 2 afternoon sessions. It will finish. Retired judges का कब रखा हुआ? Retired judges का? Central entity, they have to be retained. You can't go into under the central list, and you have a protection that that central list is based on the state list. That's not what I was saying. Central list is earlier what I was saying. But would you like to this side of the vacation or the? Yes, sir. Yes, sir. That side, not there is no hasn't been going to fall. Not it has been pending. We are not saying heavens are going to fall, but lives are at stake. Practical for hospital have also time. No heavens will fall if it is stayed also. Going on since 2010. And we can have this side of the vacation also. In any case, if you have to fix a day. Yes, having this side of the vacation. Maybe mysterious. That will not matter. We can sit in the afternoon. Let it all be done. Let it stay. You cannot debate on this. But realistically, this believes it's less fight of you. Yes. That is why now that your lordships have heard, hearing it, otherwise it was coming up on the list remaining. We have mentioned about 10 months. It let it come up in January. No, that is not fair because Mr. Sipal mentioned it. No, that is right. Or 9, whatever it is. Whatever, 8 or 9. This time it's possible only. You're going to be here, no, in that one? No, because you're quite apprehensive about your estimates. So you say that I say we'll all finish in 2 hours. It's our commitment, Your Lordship. Yes, it's our commitment. We will not pay out. That I have been hearing for last 5 years. I make this commitment on behalf of my side. Everybody begins his argument with this sentence. No, but I'm sorry to say that I given a time. This was not even a matter which can be. I was like that. I was in making that we give a commitment that we finish it very well. It's important. No, we are here because the other we have to grapple with it. Tuesday, 7 January, and so that if we keep it this side of the vacation, then we don't know whether we'll be in a position to extend it to the next day or not. But at least if it is in the January, if it doesn't get over on one day, we can have some time. From the morning then, from the morning, yes. Can it be over, that's fine. That's item 1. Item 1, yes. Item 1, that's fine. In the meantime, can you just yes, given. In 5-10 minutes, just give an overview. I'll give you losses. I'll give you losses that for overview. But as the state of West Bengal, yes. As your lordship now knows, that several states have their own backward responsibility. The state of West Bengal, has a minority population of about 28%, out of which more than 27% are Muslims. The Nalana's Commission, in its recommendations, recommended that 10% reservation should be there for Muslims. As far as the Hindu communities are concerned, there were 66 communities that were classified as backward. As far as the Hindu community were concerned. Now the question arose, and that's the majority, mothers. The question arose, mothers, as to what is to be done to pay the reservation for Muslims. So the Backward Commission took upon itself that task and identified 76 communities to be classified as backward. 76 of them. And mothers, most of them, a large majority of them, are included in the central list. Before mothers, this classification. That also has been struck down. Between 2010 to 2012, mothers, and this has been going on since till mothers, this judgment came in 2023. Or 24 it came, mothers. So 44 of them are within the central list. And a certain number of them are also part of the Mandal Commission. Which are recognized, mothers, by the Mandal Commission. And then the balance, mothers, are part of Hindu counterparts and in SC/ST and OBC Hindu counterparts, and then the last category in the neighboring states. So this makes up of 76. This exercise was done by the Commission pursuant to the hearings made. And the Commission was recognized these 76. But unfortunately, the High Court has struck it down, heavily relying upon the Andhra judgment, your lordships will remember, where the 4% reservation was there for Muslims. That judgment had been stayed by this court. That judgment has been stayed by this court, and that matter is pending before this court. Whether or not Muslims are entitled to classification or not has been stayed, and that reservation is continuing in Andhra Pradesh. And the High Court here relies heavily on that judgment. So that's my God. It's just getting on overall broad. So that's the issue. Now, when the state of West Bengal, the West Bengal Commission decided on these backward communities within the Muslim community, then the issue of sub-classification came. And we decided to do an exercise. Now, as far as the inclusion within the backward classes is concerned, that was done by the Commission. When it came to sub-classification, that exercise was delegated to the Calcutta University. And there's a CII, Department of Anthropology. CII did that exercise. And that recommendation was sent to the Commission, sent to the government, and the government recognized the other backward classes within the backward communities. And there were 140 of them.
Other backward classes within the backward community?
Within, like the constitution and judgment, sub-classification.
Sub-classification amongst the scheduled castes.
That's correct. So that exercise, your lordship, has now been upheld in the constitution and judgment. That also has been struck down. Not only that, but the act itself has been struck down. That the government does not have the power to do this. So there are highly contentious issues involved. And part of the argument of the other side is that the exercise that was sought to be done was not done properly. A learned friend will demonstrate to you that everything was done properly. In fact, we have set out in this note the meetings that were held, the public hearings that were held, the number of times that we went to those particular areas where the backward community resides, and all that was done by the Commission itself. When it came to sub-classification, that your lordship knows the government is entitled to do that. That's not a task of the Commission, but that was delegated to the CRI.
That also can't be done unless there is a quantifiable data.
That is there. All that is there, That quantifiable data is there, and the identity of the sub-classified categories are also here. So that also was struck down. But what is important is that the provisions of the Act itself were struck down, that you can't delegate this. So these are very serious issues involved. It affects the lives of thousands of students, who are aspiring to be admitted to universities, people who are wanting jobs, and therefore it's not. And if in principle Muslims cannot get reservations, that's another issue. But if they are entitled to reservation, then this question arises as to how this is to be done. And according to us, this was all done.
Reservation can't be on the basis of religion.
That's what the argument is, which has been stated by this court in the Andhra matter. It's not its backwardness. It's not the argument. Go on.
It's a very utopian kind of argument which my friend is making.
If you don't mind,
Once the court finds this,
We'll also hear
this is a unique way of arguing nowadays in this court, we are not.
And with this, is it possible to stick up to the 2 hours?
I will stick up. When I have I sort of, I admire the patience of the other side, and they will let us argue for 2 hours without interruption. And we'll appreciate that. So we will certainly finish in 2 hours. The question is, this is not on the basis of religion. This is on the basis of backwardness, brothers. Not on the basis of religion, which your lordships have upheld. Even amongst the Hindus, it's the basis of backwardness. Backwardness is it's common to all sections of society, no matter which religion they belong to. It's also true of Christians. So that itself, on the ground of religion, is not the issue here. It happens that they belong to a religious community, but they are backward. And that's the question that your lordship will have to decide. And then broadly, these are the issues. Broadly, these are the...
Cruising down the highway, yeah, I got you by my side. Whoa. Every drive feels safe and special with collision mitigation braking system.
Of the act, irrespective whether... Sorry. Yes. At the bottom of page 209. Yeah. The opinion and advice of the Commission is ordinarily binding on the state legislature under sections 9 and 11 of the Act of 1903. Irrespective whether a request to look into over-inclusion or under-inclusion is made by citizens or body of state. The expression Government of West Bengal and Government in section 2F of the Act is then down to name State of West Bengal in discharge of its legislative functions, having due regard to the reports of the Commission under the Act. Now the next is important. The second part of section 2H of the Act, which reads, and I quote, and includes such classes as the state government may by notification in the official gazette specify from time to time is struck down. Because how can such an act or such a provision be struck down? That the state has no power. When the recommendation
this will be contrary to Chennai.
Exactly. It just cannot be struck down. They've struck it down.
Said because the commission did not do it.
Commission did it, brother. Commission did it.
So you said it was given to the university.
No, that's for sub-classification.
That's what it is.
Inclusion is done by the commission. Inclusion is done by the commission. Include such classes. The inclusion is done by the commission.
I see the provision of the act is
Yes. When we see the act says, well, this is very strange. It says 517 volume 2. Lists means list prepared by the government of West Bengal from time to time. And H is other backward classes shall mean such classes of citizens as specified in Schedule 1, other than Scheduled Class and Scheduled Tribes, and include such classes as the state government may by notification in the official gazette specified from time to time. Struck down. Commission recommends and be notified. How can this be struck down?
The power is executive.
Yes.
We are not deferred with the commission, brother. Whatever the commission has told us for inclusion, it's the act itself is struck down. The section itself is struck down. So this is completely wrong. Now, can you see the next? It says section 16D is struck down since it empowers the state executive to amend any schedule of the Act of 2012, including Schedule 1. Consequently, the 37 classes included in the exercise under 16 are struck down from Schedule 1 of the Act. And similar 16 saying the state government may by order published in the Gazette add to or amend or alter any schedule. That itself is struck down. If we do something at the instance of the commission and we alter it, it's struck down. The power is struck down. It's against the constitutional judgment. Schedules can be amended, but power is with the government and the legislature has given that power. So then now see, 5A. 5A of the Act, one second, let me read. Of 2012, it distributes the percentages of reservation in 10% and 7% to the sub-classified classes is struck down. Consequently, the sub-classified classes listed in the two categories, namely OBC A, OBC B, are struck down from the schedule. So the sub-classification is struck down. And what does 5A say? Subject to the other provisions of the Act, 10% of the vacancies shall be reserved for candidates belonging to other backward classes, donated as other backward classes category A. Category and 7% of the vacancies shall be reserved for candidates belonging to the other backward classes category B. Category of the other backward classes in this is structured. So I can't have a classification of other backward classes. It's contrary to the constitutional judgment. which is why we said that this has been continuing since 2010, 2012, struck down in 2024. Benefits have been given to us over the years. And then when it was over the page at 211G, the executive orders dated so and so, issued by the government of West Bengal, backward classes welfare department, subclassified 143 classes are struck down. And then the executive orders classifying, no, this is important. The H is most important. The executive orders classifying 66 classes prior to 2010 are not interfered with since the same have not been challenged. These are the Hindu pillars classification of backward classes of Hindus. 66 pillars of them, they say we can't strike it down because nobody has challenged it. The same process is followed prior to, whereas the process followed afterwards, whether it is struck down, process followed prior to the same process is not struck down because it's not been challenged. I mean, this is bizarre, brothers. Therefore, constitutionally, ex facie, this High Court order has to be stayed, brothers, with the greatest respect. And then 200, para 2, brothers.
Para 2 at?
So, inclusion struck down, sub-classification,
Class J. Class J.
Clause J, mother. Backward classes, welfare department of the state in the exercise of power under 11 shall in consultation with the commission place a report before the legislature with recommendations for inclusion of new classes or for exclusion of remaining requirements. Where's the question of legislature coming in here? This exercise is to be done with us. If the legislature were to do it, you will strike it down saying it has gone to the backward class commission. If the backward class commission does it for us, you say it should be done by the legislature. And your lordships have deprecated the practice of the legislature deciding this because they have their own political considerations. So, brothers, with the greatest respect, it is my humble submission, brothers, since this
Class K doesn't make any.
Yes, the services of citizen from the 77 classes and 37 classes added in the exercise of section 16 struck down or already in the service of the state have already availed the benefit of reservation of succeeded shall not be affected by the reason of his judgment. That's this year onwards for us. We can't do anything. No reservation at all, brothers, in admissions, no reservation in employment, no reservation in promotion, no reservation in scholarship. So what kind of orders are these? I said promotion orders. So brothers, with the greatest respect, it's fine, your lordship may list it anywhere, but some interim order has to be passed, brothers, to help us.
We'll hear it.
Yes,
I think that we'll hear it.
Your lordship wanted a bird's eye view, brothers, I give it to
How
you.
we must hear Mr. Patwali has already.
Yes, yes, of course. There are so much for the sitters. But if they are very what? Yes,
Yes. In any case, we are not hearing it today. So, unless if you want to say something.
What on behalf of petition, if I may have just 2 minutes. One of the reasons not given is that the Muslim counterparts, these that a barber who is Hindu is included, obviously. But a barber who is a Muslim, if he is not to be included, that is said to be based on religion. And just I'll just read two paragraphs. He says, High Court says at page 174, there is a set of classes who once belonged to the Hindu religion. Page 174. There is set of classes who once belonged to the Hindu religion and are stated to have been converted to Islam. The Commission does not, however, advert to the question of why such classes converted. As to when and whether such conversion was done for getting a reservation for the state services. Here by conversion they are losing. Where is the question of converting? Has not been considered. Most importantly, some of the said classes were enjoying reservation as scheduled castes when they were Hindus. The question therefore that would arise is why a class which is already under the reservation scheme would convert to the Muslim religion and will get a reservation based on the ground of the class having previously. So the perverse reasoning.
There are therefore serious doubt on the bona fides of the surveys.
So what is the doubt in this? What we have said is that a Bhangi Hindu is already reserved and getting reservation as a scheduled caste. Untouchables.
Why should we convert to Muslim?
Why should you have converted to Muslim? So because of conversion, now he can't be included in the scheduled caste because he is not notified. But he is backward. He has been included as a backward class, not as a scheduled caste. So person who is Dalit doesn't cease to be a Dalit on the face of it explicitly.
No, but as far as ST is concerned, if he is not from those religions which are listed in the presidential order,
They have not been included in SC/ST. They have been included as backward class.
because scheduled caste would be only restricted to Hindus.
Some laws and five judges in Journal 6 says scheduled castes are backward class. I can't include them in SC because President has not included them in the list. That's correct. They have therefore not been included in the SC list. But for that reason, there is no prescription under the constitution that they can't be included as a backward class under 16(4).
Learned judge relies on journalism.
Yes. And just look at this, the bold portion at the bottom goes against the end of the judgment. The test for requirement of social and ethical cannot be applied to the scheduled caste. They are deemed to be. So at least they are backward class. It's not in the category because of non-notification. Now the second thing is this, Lord. If all these counterpart Hindus are already included in the backward class or scheduled caste list, if you do not include the counterparts, then that is exclusion based on religion. This is not a case of inclusion based on religion, but it is a case.
If you are thinking your baby's skin color will change by just applying a cream, then you are wrong.
Exclusion based on religion has been undone.
Yes, Mr. Patel. We just wanted to have an overview. We will be hearing everyone.
Now this part has by the High Court. And the High Court takes
What Indra Sari says that the Muslim community can be considered as
Then it is a class and not a caste.
now that is being listened up singing on the list. That precisely what the error census, and the majority of OBCs in West Bengal are in fact Muslims. Because that historical context has been completely missed by the High Court. If majority of OBCs are Muslims, of course, most of them properly examined by the Muslim community. The High Court has been over-impressed by the fact that how can there be so many Muslim castes without examining the fact version which happened 200 or 300 years back were mostly of Muslims into the OBC. That's one I can.
conversion of Muslims into OBC or conversion of Hindus into Muslim community. Yes, Mr. Patel.
Now, what the point is, the High Court finds, and my friend has argued this survey was conducted, that data was there, this happened. High Court finds there is no survey, there is virtually no survey, there is no data, the commission has been bypassed. What actually happens is statement is made on 8th February 2010 by Honorable the Chief Minister of the state. Prior to that statement, from 94 to 2009, there are total 66 classes declared as backward classes. On the date the statement is made, within 3 months, 42 classes are declared backward classes for inclusion. 41 are Muslims and the rest are others. Within the next year, 56 more OBCs are declared. So, just close on the heels of the statement, over 108 classes are declared backward classes. The High Court, we move applications under RTI saying, what is the survey? Where is the quantifiable data? Indra Sani and subsequent judgment says, you cannot do it unless you reach a court a finding of backwardness. It comes out, there is no survey, there is no data. And therefore the order was passed by your lordships on the very first day when they wanted an interim order. Please show us what survey was conducted and what data was there. High Court has examined it at a number of places. For illustration, see page 150, paragraph 266. Please see this. This is all, the commission is bypassed completely. When they make classification, it is their pleaded case, we have bypassed the commission. The High Court finds serious flaw with that also, I'll show that. Just see page 150, paragraph 266, the heading is the haste. You want to know that? Page 150, paragraph 266. And therefore the High Court said, you can do it, but please conduct a proper exercise and do it. And reach a proper conclusion. Now see paragraph 266.
The High Court says that the backward classes, the Social Welfare Department of the State Bengal, in consultation with the Commission, shall prepare a classification and place it before the legislature.
Yeah, that's the act. We will show the act also, but just see the act. Basically, what where the High Court has had against them.
How can a provision of a statute be?
Enabling provision.
There it was.
On the contrary, right from Indra Sani, it is held that it is the power of the executive.
Yes, but
Classify and identify.
they diluted it. The provision was
An act of identification, classification, one can understand to do. But how can on that ground the provision in the statute be set aside and enable the state to?
It was diluted to make the commission's consultation not mandatory, but
Misuse of a provision, can it be ground for setting it aside?
basically what the High Court says is inclusion of these castes is bad. Please have it.
Then you should not have struck down the enabling provision.
Not enabling, because the High Court finds on account of that enabling provision, which says ordinarily consulted, the commission is being bypassed. And if your lordship wants to see, I will just show that now first. Please have page 87. Please have page 87. It is not, in fact, the judgment is a sequitur to what went before the High Court. Please have page 87, clause E, the heading. The state could not have bypassed the commission.
Bad. On account of non-consultation with the commission. But on that ground, how can it set aside the provision which enables the state government to classify and identify?
It is still the powers of the state government. But without bypass. Just see page 87 will be for him. Page 87.
Read 210 clause C.
Clause C. The second part of 2H, which reads and includes classes as the state government may by notification in the official gazette. The state government cannot do it. This direct power. Of course, ultimate notification may be by the state government. But the state government.
How can you confirm such a power?
What the High Court finds, the state government is merely issuing a notification. Your lordship can consider this direction. What the High Court wants to say is that the state government, without quantifying.
What the High Court wants to say can't be what Mr. Patwalia says. It has to be read from the judgment as it is.
Your Lordship sees the judgment, Your Lordship.
Unless you have some power to read the mind of the learned judges.
Just to come to this, please see 2 or 3 pages with me. Please see page 87. Page 87, para triple 1. I will read everything, which I want to read. Page 87.
Yes.
Yes. Now kindly see para triple 1. The state could not have bypassed the commission even while sub-classifying the classes. On a query from the bench as to why the state did not consult the commission while sub-classifying the classes, or why it did not at least forward the report of the anthropology department of the University of Calcutta to the commission for its consideration and advice, the learned advocate general said, possibly the state wanted to have benefit of a much higher expert body than the commission. In this regard, the court notices. So everything is being done by notifying everything, but the commission is being bypassed. So therefore, the High Court steps in and rightly so. In this regard, the court notices composition of the commission as indicated by section 3 is set out as hereunder. Then para 113. The commission comprises a social scientist, 2%. Then it goes into the details of what the commission comprises of. It goes into various judgments, and then ultimately, your Lordship may come to page 101. The conclusion is at para 141. After noticing all judgments on this at 141, please have the conclusion. Repeatedly, the court finds the government has been bypassing commission. Just see now para 141. In the facts of the present case, your Lordship, in the facts of the present case, the petitioners have successfully shown, and the court has found that the state did not consult the commission while making some classification of the classes. The petitioners have also demonstrated that classification of the classes by the state is not supported by any cogent and scientific report or recommendation of the commission. The court in the course of hearing has noticed that section 9 has been amended by the state for diluting and to some extent negating the advice of the commission. That's the reason.
How can that be reason for setting aside the...
So, Lord, your Lordship can by a judicial order say that this is mandatory procedure, the purpose of the amendment. Now, see the prior and later. Prior says this cannot be done without consulting the commission. Advice of the commission shall be binding. Now,
this is under the concurrent list statute, is it?
Correct. And then they amended by saying ordinarily binding, by introducing the word ordinarily.
What did it have? Presidential assent?
That's not coming out of the judgment. I can check out. But please read a little further with me. Your Lordship will see what has been happening. It appears at this stage that the state has been making an invidious attempt.
How would it come in concurrent list?
No, it's not.
List 2 then.
Yes.
No, the original statute, the Backward Classes Commission Act,
93.
that's a...
Every state has taken that.
There is a background to the settings that they are arguing. They have taken out literally one portion from the Hindu law and read it to bypass. It appears that the whole thing is illegal. No. There is an entire reasoning with the High Court for this. There is a 1993 State Act for us. That State Act in terms.
Yes, please.
State 2 list.
Yeah, I read that argument.
Look, sir, 93 Act was made by all states based on Indira Sanghi. Indira Sanghi said state has the power for 16, 15 to make provision for reservation for backward classes. But then twin tests have been satisfied. Backwardness, and so far as 60 is concerned, inadequacy of representation. Indira Sanghi, paragraph after paragraph, opinion says you must have a backward classes commission of experts to advise the state. Based on that, all the states have made legislation. State of West Bengal also made this law in 1993. What they do is, they are supposed to have taken an opinion on the Backward Classes Commission in 2010 to add 42 communities in the first branch and thereafter 35 in the second branch within a few months. That itself takes place after a specific political statement is made by the Chief Minister saying that a particular community today is going to be provided reservation. This fact is a very, very important fact. Admitted by the state and the Backward Classes Commission forms one of the most important grounds for the judgment itself. That's noted in para after para. Now, that exercise provides result in that list being made of 42 plus 25. What the state does in 2012 is make an independent law for the purpose of 16. In that law, Mr. Civil, where the second part of the definition gives them the parallel power without referring to the commission to make reservation. the state for it to make reservations independent of the commission. That part alone is therefore set aside. That is one part. That's the most important part. In fact, there are a number of pages reserved in the April order that we just wrote getting along from. In the April order, they have given the army great detail in the High Court. That's why I place in all this verse. You see, the April order index. There is a separate discussion on this point. That's one more way more. Point number H.
Okay, we'll hear.
That's second point. They are arguing saying that no reservation, the same complete they are placed in the same position as what they were in 2010 prior to this influence. That's the second thing. It's a different level. The High Court has found in some cases there's an application in a printed format which is given by our community. They say the hearing takes place on the same day. No one-way survey, nothing at all. No survey at all. That I would have come to that. But just someone itself at different levels. Just see para 143. It appears at this state has been making an invidious attempt to negate and ignore the advice of the commission. Very strong words for
advice.
And secondly, my lord, the court therefore says in our please. So this is Mr. Sibbal just made some comment of parallel. Now, my lord, kindly see page 146. This court needs to examine by judicial review whether policy has been examined.
Reserve your energies for service.
You just ask them, what is their locus? How are they here? Before the High Court, how are they in the High Court for them? They are not. This is some public interest litigation. Commission PIL, this is truly PIL, P in inverted commas.
You want to take away our jobs and then say it's a
PIL.
take away our jobs.
And the commission has been consulted throughout.
You have annexed the survey report.
We next the survey report.
There's much to be said about those survey reports.
That's fine.
Your friend is saying there's no survey.
Can file an appeal. What's their location and Mr. Sibbal?
Yes. That's important.
He thought we were
There are comments made on the commission. That's why. That's why they're fighting. Anyway, let's not get into this. 7th point. I don't want to say.